Good evening, everyone. My name is Izzy, and I would like to welcome you all to the Harris Law Firm's webinar series, Wiser Together. Tonight's webinar, we're going to be discussing protecting your rights as an LGBTQ plus parent or spouse, and we are incredibly grateful that you are all able to attend. As a member of the Colorado community for over 30 years, the Harris Law Firm has always tried to give back. This and future webinars are a free service that we provide to that Colorado community. Now, I would like to introduce our presenters today, Katie Ellis and Jennifer Workman. Katie Ellis is a partner at the Harris Law Firm. She's been practicing law since 2007. She clerked for the Colorado Court of Appeals for 1 year before moving to private practice in the areas of family law and estate planning. She's involved with the American Inns of Court, the Colorado Bar Association, the Colorado Women's Bar Association, and the Colorado chapter of the Association of Family and Conciliation Courts. Katie practices as a trial attorney, an appellate attorney, and a transactional attorney. Jennifer Workman is an attorney at the Harris Law Firm. A Colorado native and a child of divorce, her connection to family law began at a young age. That deep and personal understanding of how divorce can affect a child and family led her to pursue a career in that field. Before attending law school at the University of Colorado at Boulder Law School and Charlotte School of Law, she earned a bachelor's degree in English from the University of Colorado at Boulder with a minor in philosophy. She now focuses her time handling cases involving probate, estate planning, and other family law issues. Without further ado, I will turn it over to you, Katie and Jen.
Thanks, Izzy. So one point of housekeeping on our end before we get started is just a general reminder that this webinar really can't be legal advice for anyone who may be listening to it. We don't know the ins and outs of your particular situation, and these cases are always incredibly complicated and fact specific. So if you are experiencing an issue that's related to what we're talking about here in this webinar, please do reach out to an attorney, either one of the ones at the Harris Law Firm or someone at another firm that addresses these issues, and get some legal advice about your actual case. We will, however, hopefully share some general information, tips, and advice about sort of what you should be thinking about when you're grappling with these issues, and hopefully that will be helpful to you. By way of a brief overview here, the general stuff we're going to go over tonight include sort of the legal framework that this is all operating under, and why this even is an issue that we're discussing. We'll talk a bit about some of the areas of concern and things that you can do to minimize risks in family law specifically, but also in areas of estate planning, surrogacy, and tax law. And then we'll save some time at the end in case anyone has questions. So as far as why we're even putting this webinar on, the legal sort of environment and political environment surrounding LGBTQ plus issues in the last couple of years in particular have been very turbulent. There is a lot going on that's very concerning and scary to people in that community and people who love people in that community. As of a couple of months ago, there had been more than 500 anti-LGBTQ plus bills proposed within the United States. So that's across the 50 states and territories and federally and everywhere else. And those bills are targeting a host of different issues, including gender affirming care, the right to use bathrooms that people are comfortable using, discussion of these types of issues in schools, and even access to literature that addresses LGBTQ plus issues, athletic participation, right? There's been a whole lot of that recently with whether schools are going to receive funding, if they allow people, transgender people in particular, on their athletic teams, and even voting rights, you know, as we're seeing targeting about your name having to match your birth certificate and all of that, really seeing a lot of very concerning issues that are causing many people to have questions about whether the contracts and agreements and court orders that they've been relying on are valid. And so we're approaching the discussion tonight with an eye toward identifying some of the things that has people in this community very concerned. And it's our hope that by addressing some of those issues and providing at least some solutions or things that may help mitigate risk, that we can give people a place to kind of channel all that anxiety and apprehension about what's going on into something productive by, again, at least taking some positive steps that can make some of these big, scary issues a little bit less big and scary, or the risks a little bit smaller. So, the specific legal framework that we're working with, Colorado is actually an interesting place to be. In one sense, it is generally considered a fairly safe state within the United States for LGBTQ plus rights and issues for a lot of reasons, but it has a pretty interesting history with these issues, right? And a lot of ups and downs and contradictory policies. It certainly is not a model of support for this community. So, way back in 1975, the Boulder Clerk had the distinction of being the first to ever issue a same-sex marriage license within the United States at all, which was amazing, right? They issued several same-sex marriage licenses. That was a huge step forward, but at the same time, other Colorado state officials invalidated the licenses. So it's a great step, but it's obviously not, indicative that there was a wonderfully supportive environment there. In 1992, Colorado voters approved Amendment 2, which prohibited laws protecting LGBTQ plus individuals from discrimination. That is the law that resulted in the Romer versus Evans U.S. Supreme Court case that said you can't do that, right? You can't prevent laws that protect people in that community. Looking a bit more at some of the sort of family law and marriage related issues, way back in 2007, Colorado was allowing same-sex couples to adopt children jointly. That was a big deal and a very big step. And it's something that we'll talk a bit about when we get into some of these sort of confirmation adoptions and other tools that we have to create more security for couples. In 2011, we also prohibited discrimination based on sexual orientation and gender identity in schools, which is another good step, toward equality. In 2016, Colorado allowed transgender individuals to amend the gender markers on their birth certificates without having surgery. Again, another big step toward recognizing people's right and ability to self-identify. In 2013, Colorado legalized civil unions, which was a great step in the sort of marriage equality field. But at the same time, we had other issues going on, including language in the Colorado Constitution defining marriage as being between one man and one woman, which is problematic. In 2015, the U.S. Supreme Court legalized same-sex marriages nationwide. In 2019, Colorado banned conversion therapy for minors, which protected youth from practices aimed at changing sexual orientation or gender identity. And then in 2021, Colorado also enacted the Promoting LGBTQ Youth Mental Health Act, which really did help to establish some mental health support for youth in foster care and juvenile justice systems, which again is another positive step. But most recently, finally, in 2024, Colorado voted to remove the provision in the Constitution that defined marriage as being between one man and one woman. So there's a lot of ups and downs there, a lot of things that, while taking steps forward, there's still this legacy of discrimination in the background. But we've presented this here mostly because we wanted you to understand that there are some positive steps in supporting this community in Colorado, but it is not an easy road, and it's not something that was always very clear. All right, in the arena of family law, some of the areas of concern that people have been expressing to us are concerned first and foremost that their marriages may no longer be recognized, right? There's obviously a lot of political opposition to same-sex marriages right now. And so there's some genuine fear that that is going to fail and that, people will not be able to marry the person of their choice, but also that some of those existing marriages may no longer be valid. The good news is Colorado continues to recognize same-sex marriage, right? But nationwide, there's definitely some challenges. And so we'll talk a little bit about that when we get to some of the possible solutions and tools at people's disposal. Another issue we're hearing a lot are concerns about parental responsibilities for children of same-sex couples, right? And how to make sure that if you do have a same-sex couple who've been raising a child together, that the right to do that will be recognized, right? That they will be able to both have access to their children's records, to make decisions about them if something happens to them, that those rights get protected as well. Similarly, the enforceability of marital agreements. Jen and I both draft those and litigate cases involving them. And I know both of us have been adding some additional language in our marital agreements to make sure that when these issues are part of what we're dealing with, that we have sort of belts to go with the suspenders to make sure that there are that there is recognition for the validity of those agreements. And then lastly, I mean, certainly not lastly, but the last big category of concern that we've been seeing are the enforcement of these orders in other jurisdictions, which is certainly a valid concern in an environment where we have other states that are choosing not to recognize same-sex marriages anymore. So that's something we'll touch on a little bit as well. In terms of minimizing the risk, within marital agreements, separation agreements, parenting plans, it is a good idea, if it makes sense to do so, to recognize or include language that the terms of those agreements would be enforceable even if the law doesn't recognize the parties were married. So something that says, this is how we want to divide our property. We are doing this as a married couple, right, who is in the process of a divorce. We are doing this under the assumption that we are legally married because we are in the state of Colorado. However, if at some point in time the law changes and our marriage is viewed as not being valid, we still want our property divided this way, right? We still want the same result that we're getting, and it's not contingent on the fact that we happen to be married when we're making this agreement. Jen, I don't know if you're doing kind of similar stuff with some of your agreements, or if you have other kind of language in those documents that you're including as well.
Yes, and those, and especially the estate plans as well, that has been a big issue. And I know that we're going to go into the estate planning next, but absolutely in marital agreements, separation agreements, parenting plans, and estate plans, making sure that all those rights are transferable, even if you are not deemed married in a state or federally, if that is no longer possible.
Related to that, in parenting agreements, right, when you're dealing with orders about custody, about who gets to make decisions, who the kids are going to live with, what that schedule looks like, same kind of thing, right? Making it clear that that the parents believe that that is in their children's best interest, regardless of whether their parents were ever married or not, right? That they have that relationship. And fortunately, in Colorado, the parental responsibilities piece isn't affected by whether the parties are married, right? You use the same analysis to determine what is in the children's best interest, whether the parents are currently married or divorced or were never married. And frankly, even whether they're not both parents, right? So if you had a scenario where you have parental responsibilities between a step parent and a parent, right? It's the same framework for deciding best interests, with some nod to the fact that biological parents get a statutory preference, right? In terms of believing that what their belief about what's in their children's best interest carries more weight. But when you're talking about an agreement between the parties, between the grownups, that doesn't really matter, right? And so what we want to do is, again, make sure that it's just clear in the agreement that if someone comes along later and says this couple wasn't actually married, that the parenting plan would still be enforceable. And then the slightly trickier one, that's a very simple thing to do, but I think people often forget, is making sure that if parties go by more than one name, or have gone historically by a different name, that you're using all of those names in any of the stipulations you're entering into, right? So if someone if you have a transgender individual who has changed their name and is currently going by a different name than the one they were given at birth, that you're just including both the birth name and the name that they're currently using, which is frankly fundamentally not much different in concept than including a maiden name and a married name, right? For someone who changed their name when they got married. So just making sure all those names are there, so there's no confusion, no ability on anyone's part to say, well, this agreement isn't valid because that's not their real name. Just acknowledging all of these names are, the same person. So. All right, estate planning is one of the areas where we're seeing, I think, even more anxiety about some of these issues. And it's understandable because although we would like to believe that our families are supportive of our life choices and of who we are as people, that's not always the case. And so with estate planning, among the areas of concern we have is just fighting among family members, right? And children of an LGBTQ parent, for example, not understanding or respecting or appreciating that their parents' sexual orientation has changed during the course of their life, or that they've acknowledged a sexual orientation that they maybe were not comfortable sharing when they had children. It can create a lot of tension within the family. Related to that is family members not respecting wishes, right? And thinking that they know better than a parent or spouse's new partner, what would be in that person's best interest. So protecting within that realm as well, stepping aside from the issues of the family fighting, even when you have the family aligned, there are always concerns now about protecting your spouse's right and protecting your children's rights if something happens to you, because of all of the benefits and the rights that stem from marital status and stem from legal status as a child, right? That parent-child relationship in a legal sense. So in terms of addressing some of those, what you can do to protect your rights, the first and fundamental one, and I'll give Jen a minute to talk about how this is so important, is very basically create an estate plan. If you get nothing else out of this, please, think very seriously about creating an estate plan. And I'll let Jen kind of talk through why it's important to write it all down instead of just trusting that things will go in a good direction.
Yes, so in most states, but obviously here in Colorado, because we have ratified same-sex marriage and we've provided those rights to same-sex couples or LGBTQ plus couples, typically without an estate plan, your spouse would still be able to inherit or make claims against an estate in the event that you predeceased your significant other, your spouse. Because of that marriage and that institution of marriage, we have these defined statutory rights as a spouse that one would inherit. However, if the worst case scenario happens and those rights are no longer recognized federally or by the state, then your spouse would not be able to just inherit because of your relationship. And you would need to have an estate plan in place if you wanted to allow your spouse to inherit from you or your partner at that point, and to make sure that they would be able to get anything that you wanted to leave them. Obviously the most important aspect is if any person or couple has a house and it's only in one party's name, you want to make sure that maybe your spouse can continue to reside and live in that house. Same thing with beneficiary designations on accounts, that you make sure that they would be able to inherit those in the event that you just put your spouse or you acknowledge them as your spouse through the beneficiary designation when in fact they were allowed to be a spouse and maybe they're no longer allowed to be one in the future. And then most importantly is if you ever, like here in Colorado, we are able to give those rights because we do recognize same-sex marriage. But if you ever move to a state in which does not recognize those same-sex rights, you want to be particularly careful that you have an estate plan that designates your significant other as a person to inherit from you. And then that's just inheritance. Obviously, the next step would be powers of attorneys and allowing your significant other to make decisions for you if you ever become incapacitated, and vice versa, you being able to make decisions for your significant other if they ever become incapacitated and cannot make decisions for themselves. For one reason or another. So you want to make sure that you have a medical power of attorney and a financial power of attorney naming your significant other so that they can make decisions in the event that something happens. And that also goes for an advance directive if someone's going in for surgery or something to that surgery, or has some medical ailments that they might be in a hospital for some reason, that you want to make sure that there's an advance directive that names your significant other who's making decisions for you, and have clear instructions that they're the person that you want to make those decisions on your behalf because you view them as your spouse, even if they're not acknowledged under a separate jurisdiction or under the law as your spouse. So those are the most important things when it comes to spousal rights. And then the obvious next step is the protecting your children in the event something happens to you, and making sure that you have a delegation of guardian, which would delegate your significant other and spouse as the next person in line to take care of your child in the event that you predecease them and you're in a state that doesn't recognize same-sex marriage or LGBTQ marriage and rights. And then, or if the federal law changes and we can no longer support that under Colorado law for some reason. So those are the kind of big things, making sure that you delegate your significant other as the next appointee as a guardian, and then you also give them power of attorney. And this will also greatly depend if you have a birth certificate that reflects both you and your significant other as the child's parents. And we'll kind of go down that route when we do the confirmation of adoption. And then also, I know that there's some questions about making sure that birth certificates reflect certain names and certain individuals on that. And that's another thing that we can help with, is making sure that the birth certificates clearly reflect who parents are. But we'd always strongly recommend that even if you have a birth certificate that reflects both parties as same-sex or LGBTQ plus parents, that you also ensure that you do the delegation of guardian and the powers of attorney to make sure that your significant other has that contractual right to also make decisions on behalf of your child.
So in addition to creating the estate plan, it's also really important that you discuss that plan with the important people in your life, right? One of the worst things you can do is have it be a surprise, right? That, oh, I'm supposed to be making all these decisions, but I don't know what my partner wants. So make sure that when I say the important people, obviously the people you're designating to make decisions or care for your children should know that that's coming, right? So they have some ability to plan for that. But also the people who might think that they're the ones who are going to make decisions, right? If you're in a scenario where you don't want your adult children making decisions for you, you really want your partner to make those decisions, talk to your children too and make sure they understand why you're doing that, right? If you're choosing one child over another, right, it's a good idea to have conversations with them so that they're not left guessing, why doesn't my dad trust me to make this decision for him? Why isn't my spouse, like, why is my spouse letting their adult child make this decision instead of me? Do they think I'm going to do a bad job? So if you can have that conversation with those people, it can really make things a lot easier and maybe minimize some of the hurt and therefore hopefully some of the fighting. And then make your instructions clear, right? I'm going to talk a little bit more about that in a minute with sort of last wishes documentation, but most of the infighting can be avoided if you write down your wishes. And sometimes if you explain why, if you can provide a reason that you're leaving the house to one child and not another, or to your partner and not your children, it can, again, help quite a bit. It's also not a bad idea to have sort of contingencies in your estate planning documents that address the same sorts of things we were talking about in family law, that if it is later found that your marriage to your spouse, well, that same-sex marriage, for example, is not valid, or that you're not a legal parent of a child who you believed you were a legal parent of, that you would still want those gifts to succeed, even if that status isn't there, right? And so be specific in your estate planning documents. Don't just say to my wife, I leave fill in the blank. It should identify them as your wife, but also identify them by name and make sure it's clear that even if that person is not your wife because of an invalidity of marriages in general, right? Obviously, if the two of you get divorced, that's a different story, but making it clear that if there's a legal change or a political change that results in the marriage becoming a nullity, that you would still want those gifts to succeed. Some of the tools you have at your disposal that we'll talk briefly about are, I think, what most people think about when they think estate planning, that sort of wills and trust category. But there's also final wishes documentation that can be really important, powers of attorney, delegation of guardian, confirmation adoptions, all of these other tools that you can use in the estate planning arena. With regards to wills and trusts, again, we've already talked a bit about why LGBTQ plus spouses should be preparing appropriate estate planning documents that very clearly name their spouses as the beneficiaries, and then make it clear, again, that you would want those gifts to succeed, even if the law changes to invalidate same-sex marriages. And make sure your family and members know where to find your estate planning documents. That is another thing that, as much as usually movies get it wrong, there is something to the idea that all of a sudden we found grandma's new will in the attic and nobody knew it was there, and it messes everything up, right? So because Colorado in particular doesn't really have like a registry where you can go file these things, you need to make sure that the people who you would expect to be involved if something happens to you know where your estate planning documents are located. Maybe they even have an electronic copy somewhere so they can compare it. And if you update those documents, or if you don't want those documents to be binding anymore, if you want to tear them up and start over, tell them that, right? Make sure they know, hey, remember in 2015 when I talked to you about my will? I've completely redone it. The one from 2015 is no good. There's a new one from 2025, and I keep it in the safe in my office, right? Or I keep it on file with my lawyer. Here's their name so that your family knows where to find that stuff. And I say family, I mean that kind of broadly, right? It may be your best friends that are helping you with this plan, but the important people should know where these things are. One of the documents that I think often gets overlooked in estate planning is something that addresses your final instructions. There are a lot of different names for these because it's not like a legal term of art, but it's the document where you're listing out what you want to happen with your own person when you're no longer alive, right? So do you want, on a basic level, do you want to be cremated? Do you want to be buried? There's all kinds of creative new ways that human remains can be dealt with and managed. Which of those do you want? And if it's something expensive, have a plan for how that's going to be paid for, right? If you're being cremated, what next, right? Where do you want those ashes to go? If you're being buried, do you have a particular cemetery that you want your remains to be placed in? Um, do you want a memorial or a celebration of life or a funeral or some other sort of service or none? Right? What's your preference there? Do you want, if there is a ceremony for that, to be a religious one or a secular one? I mean, some of these are things that apply regardless of the LGBTQ rights issues, but I think they get particularly sensitive in these cases because you do sometimes have family members, and I've seen cases where a family grew up deeply religious, and when a one of the members grows up and is exploring who they are, they discover that their religious upbringing does not align with who they truly are. And so they maybe have a rupture with whatever their religion was. Maybe they have a new religion, maybe they don't have a religion. But if you leave the estate planning up to their parents, they may end up, being buried in a particular, cemetery at a with a religious ceremony that would not be what that person would truly have wanted. This is when I was growing up, this was an issue we saw a lot with, frankly, just gay people whose parents and family members couldn't deal with that. We're seeing it across the board with transgender individuals and the difficulties they're facing getting the people they care about to accept who they are. So just be clear about it, right? Put your wishes down in writing so everyone knows what you wanted. Who do you want to speak at the service, right? Is another thing, right? If you're really not in a good place with one of your close family members and don't want them to be the one talking about what your life was, you can control that, right? You can at least express your wishes so that everybody knows what you want to happen. Down, and you can get very, very particular, right? Down to things like what music they're going to play, what readings you want done at a service. In the realm of LGBTQ issues, though, one of the things that is tremendously important is also how do you want to be identified at the service, right? Do you want, if there's a memorial booklet or something, do you want it referring to you as female or male or neutral? Like how do you want to be referred to, right? What name are you using? So all of that can be included, your pronouns, like what is important to you. Understanding that there's no legal requirement that you do any of this. So you can be as detailed or as general as you want, right? The instructions can just be, please don't cremate me. And then let everybody guess, right? Or you can get more detailed, which frankly is a kindness to your family because then they're not having to guess and agonizing about whether they did it wrong. Jen, can you think of any other final instruction type stuff that we didn't really address here?
An obituary, which also goes to like the identification, like if you want an obituary, how you would like an announcement, if you want it, like, I have a lot of clients that don't want an announcement at all. And they have, various reasons for that. But then obviously if you want an announcement, where do you want that announcement? Do you want it with a certain community? Do you want it in a certain publication? And then obviously what name and gender you would like to be identified in the announcement as well.
It's a great one. All right, powers of attorney. Jen touched on this a little bit already, so we won't spend a lot of time on that. But again, making sure it's clear if you are incapacitated, who you want making decisions for you. There are durable medical powers of attorney, right, which address things like if they're going to make a decision about feeding tubes, about what care to give you, right? If you are not able to answer questions, someone who's going to decide whether to have surgery or wait and see what happens, right? If you're going to try a particular medication or treatment, and that is an area where we see a lot of fighting among families because they often don't understand again, and there's a lot of hurt if they feel like they should be making the decision and weren't trusted with that. And then I'm sorry, there are also financial powers of attorney that have very similar issues, and so bear that in mind. And I forgot to mention with the medical power of attorney too, for people undergoing gender affirming care or gender transitional care, any of that kind of stuff, the medical power of attorney can be incredibly important too, right? Because some of the decisions that are made may affect your ability to continue with the treatment course that you have decided to embark upon. So making sure in that power of attorney and frankly in your medical directives, which are another example of a document Jen talked about, that you're clear that you do not want certain types of treatments if it would impair your ability to proceed with where you've been going in your transition. So that's another important thing to think about. Delegation of guardian, and that Jen talked a bit about that as well. Again, this is where it gets very frustrating from the legal side and even more frustrating from the personal side of this, because if you are on a child's birth certificate, or if you and your partner are raising a child together, right? If your child has only ever known these two people as parents, all of those things should be clear and easy. And we should not need to also have a document that says, hey, my spouse, who's also this child's other parent, has the legal right to make decisions for our child. But again, because you don't know what you're going to be facing, this is one of those extra, belts to go with suspenders kinds of things that you can make sure that it's very clear. And Jen had talked about the idea of having that for, if something happens to you, that the other spouse, is there. It's also something you can use if you're facing difficulty with care providers, the schools, anyone else not giving you access, not letting you pick up a child, not, gaining access to records or information or making decisions, right? If one parent shows up for the school IEP meeting and the other parent can't be there, it's another way you can make it clear that, yes, of course, my child's other mom can make decisions about our child because I can't be there, or, that our child's other dad can make those decisions. And so it's just, again, another piece of evidence you have to prove that you do have the right to be there and be at the table and make those decisions. All right, and I'm going to let Jen talk a little bit about what a confirmation adoption is and why we would use that at all.
Yes, so confirmation adoptions are more informally known in Colorado as Marlowe's Law, and this came about when a same-sex couple embarked on the journey to have a child through assisted reproduction prior to the ratification of same-sex marriage or civil unions. And so only one parent, the biological mother, was reflected on the birth certificate, and they were going through an adoption process. And the custodial adoption process is very detailed, where you have to go through background checks, and sometimes there's a home study that has to be accomplished. And that seemed very unnecessary when these two people at this juncture had already been raising this child for over 10 years, and they just wanted to make sure that the other parent was reflected on the birth certificate after all of these rights had gone into effect. So Colorado adopted the confirmation adoptions and Marlowe's Law in order to make the process a lot more streamlined. So where we see this most often is for those people who embarked on this journey in advance of all the rights that we've been able to obtain over the last few years, which are now, we're now having political and legal impacts through the current climate. But in general, what you want to do is, if only one parent is reflected on a birth certificate, this is a way to make sure that both parents are reflected on the birth certificate. And then even in the event that both parents are reflected on the birth certificate, it may not seem very necessary, especially especially if you are intending to remain in Colorado, where we currently have all these protections. However, if there's any desire or intent or plan to move to another state that might not be respectful of your decisions and your rights, you may want to go through this. So you again have another layer, another protection that shows that yes, we're both on this child's birth certificate and we have engaged in adoption. We have a decree of adoption showing that we are both this child or children's parents, and this is what we desire, and that we both have rights to make decisions for this child and care for that child in the event something else happened. So a confirmation adoption is a very fairly simple process where you get to alleviate all the obligations of background checks and home studies in both but one big key aspect is both parents, so the same sex or LGBTQ parents both need to agree that they are parents for the children, and then they will go through and make sure that the birth certificate is also adopted and a final decree of adoption is issued to ratify that relationship.
And that dovetails very nicely into surrogacy, which is another issue that is more and more often something that we are seeing in our cases in general. We're seeing this a lot, not only in LGBTQ cases, but frankly in heterosexual cases where they're having difficulty conceiving, right? And really want children, or are afraid of the medical ramifications of conceiving, right? And so surrogacy is certainly on the rise as an option. And so before Jen gets into some of the particulars of this, I'm going to do a shout out for the incredible work Jen does in this area and just make sure I drill down on, if nothing else, please execute a surrogacy agreement. There is no such thing as informal surrogacy. It is a disaster. It is a bad idea all around. It creates all kinds of legal hurdles, questions about who the parents are and what your rights are. So if you are considering either being a surrogate for someone or working with a surrogate to accomplish your goal of being a parent, you absolutely need lawyers involved. You need to make sure everybody understands what you're doing, that you have a formal agreement that outlines this. And Jen's going to talk about the particulars of that, but definitely 100%, you need to have a lawyer involved. I promise you, it is more expensive and heartbreaking to go without a lawyer than it is to just do it right from the beginning. So, yeah. Jen, what law applies?
Yes, so in 2021, Colorado created the Surrogacy Agreement Act, and that was effective May 6, 2021. And essentially what this does is that we were having a lot of informal surrogacy and a lot of questions about how surrogacy is handled. And there are a lot of very case-specific, fact-specific provisions that go into each surrogacy agreement. We're never going to see a surrogacy agreement that looks the same. It is not an agreement that can be one size fits all. You have to have specific provisions and thoughts concerning what your surrogacy will look like, and how everything will be paid, and everything, who the parties are, how everything will be terminated in the event that it's unsuccessful. So we need to have a lot of very fact-specific provisions that deal with each individual scenario, and that is why the Colorado created the Surrogacy Agreement Act, was to streamline the process and make sure that there are at least some guidelines to make sure every surrogacy agreement has these specific things, so we can ensure that they're enforceable. And so the requirements of a surrogacy is that at least one party be a resident of Colorado in order to have jurisdiction, or the child's birth will occur here or is anticipated to occur in Colorado, or the assisted reproduction service will occur in Colorado. So these are all ors. So we just need one of these fact situations in order to draft the agreement here in Colorado. If for some reason your case does not fall into one of these aspects for Colorado, certainly contact an attorney in the state in which you're a resident, you anticipate the birth will happen, or the assisted reproduction is happening. So you can get a surrogacy agreement done correctly for that specific state. And then in order to get a surrogacy, all parties must be at least 21 of age. All parties must be represented by counsel in Colorado. All parties must complete a medical evaluation related to the surrogacy agreement by a licensed doctor, and the surrogate must have previously given birth to at least one child. The surrogate must complete a mental health consultation by a licensed mental health professional. And if the surrogate is married, our spouse also must sign a consent form. So those are all the things that you need in order for a surrogacy agreement in Colorado. So if you don't have all of that checklist completed, then you will not have an enforceable surrogacy agreement, and it is absolutely disastrous. It's one of the worst things that can happen to a person or a couple, to think that you're having this child and then have a third party who was not planned to be a parent have rights to make decisions and have parenting time for your child. So
And one thing that's important about that is when we say all parties must be represented by counsel in Colorado, that's not one lawyer, right? You're not all aligned, even if you all have the same goal. So the person who is hosting, right, is going to, who's carrying the child, is going to have their own lawyer. The people that are, engaging their services are going to have their own lawyer. And it's important that everybody get independent legal advice about all of this to make sure they understand what they're doing, they know their rights, and they're not walking into this blind.
yes, and one thing that isn't on the surrogacy, we focus heavily on the Surrogacy Agreement Act because we have very specific rules in Colorado for accomplishing surrogacy agreements. But one thing to also note is if you have a donor, so a sperm donor and egg donor, something to that effect, you also should have an agreement. Now, it is not required under Colorado law to have an agreement to have a donor relationship, but we highly recommend it because you could still end up in the same scenario where you have someone coming back and trying to establish rights, parenting rights towards your child. And if that was not agreed upon, or especially if you paid money for that donor relationship, that that can be a very difficult pill to swallow when you again have to give over some potential parenting rights to this stranger who you did not think was going to, stranger or family member or friend or something like that, who you did not think would have parenting rights. So while we don't have a specific act and requirement for it, we highly recommend that if you are engaging a donor or you yourself are a donor, that you have an agreement in place.
So we'll breeze through the tax law part relatively quickly here, so we have some time for questions. The areas of concern that we've seen come up with regards to tax issues are recognition of the marriage again, recognition of children independence again, and the ability to claim certain credits. So protecting your rights, first and foremost, ensure that your marriage is recognized in the state where you reside, right? Do everything you can to make sure it is very clear that you and your spouse are married wherever it is you live, because your ability to file those federal joint tax returns or claim credits based on marital status depends on recognition of your marriage at the state level. The federal government can't find that you're married if no state has found that you're married for purposes of tax law. You also want to make sure that you meet the requirements to claim your spouse and children as dependents. And again, that's establishing the right legal relationships. You want to ensure that any name changes or gender markers are updated with both the Social Security Administration and the Internal Revenue Service to prevent mismatches and delays. Because if one place says that you are male and another says you're female, that could result in your tax documents being rejected, in refunds not being awarded, in, penalties if you owe because they can't find your account. So just make sure everything lines up the way it's supposed to. And then ensure that your estate planning reflects the legal recognition of spouses as well to optimize the tax advantages and avoid unintended liabilities with that, right? So if you're leaving property to a spouse, you want to have a contingency for what happens, because some gifts as part of estate planning will be taxed differently, is probably the best way to say it, if you're leaving that gift to a spouse than if you're leaving it to your best friend or a roommate or a sibling, right? So just make sure that you've done everything you can and have a good contingent plan in case, again, at the time you're using your estate plan, or your estate is, because you're not around, that it is clear what should happen if that person is not recognized as your spouse. Some of the other things to consider in tax world are LGBTQ plus families who adopt children may qualify for certain adoption tax credits. That's a great one. Some gender affirming care expenses may be deductible as medical expenses. So that's when you should work with your CPA to make sure that you're claiming appropriate things and not things that the government is going to say no to. But don't just assume that none of it is eligible. And then Social Security now includes same-sex spouses, which is great. But that means you should also review which survivor and spousal benefits may apply to your family to make sure that you're taking advantage of all of the things that you can to minimize your tax liability. So we got pretty close to that 5:45 marker, Izzy, and that leaves us a little bit of time for some questions.
Yeah, you did. We did awesome. Okay, so we have a few questions, and as always, everybody, if you have any extra questions, go ahead and put those in that Q&A option at the bottom of your Zoom screen there. The first question, what if a trans woman changes her name and parental role on her kid's birth certificate? Is this even possible under Colorado law? And would there be problems in certain situations with having two mothers on the birth certificate?
So this is possible under Colorado law. The one big question and thing that I would have for that person that has done this or wants to do this is if they've changed their name on their birth certificate. Because obviously if their birth certificate is mismatched with their child's birth certificate, that could cause some other like unintended consequences. And then the follow-up question is, okay, if you haven't changed your name on your birth certificate, can you? Were you born here in Colorado where we allow that? Or were you born in a state that unfortunately does not allow that? So those are kind of the follow-up questions, but generally, yes, we can do it. You get one chance to change your own and one chance to change your child's without a court order. So you want to make sure that when you do it, that's what you want to do. That's the name that you want reflected on yours or your child's birth certificate. So it is possible. And you do it through vital records. And it is just a changed birth certificate form that you complete that the first time. If you have to do it after the first time, then you will need a court order in order to accomplish that result.
And to be clear about this, Colorado law absolutely allows a child to have two parents of the same gender on their birth certificate, whether that's changing it later or in the hospital, right? There's no burden or hurdle or any obstacle that prevents two men from being on a birth certificate, two women. That's completely fine. The issue would be if your legal name on your own birth certificate says your name is Sarah Smith and you have decided you're going to go by John Smith, right? And now you're going by John. If you have not cleaned up your own paperwork and your own birth certificate still says you're Sarah, you're kind of putting like a ghost name on your child's birth certificate, right? There's like a non-legal person on there that doesn't help your child, right? And so you want to make sure that when the whole point of this is to be able to advocate for your child, make decisions for your child, prove that your child belongs to you, your birth certificate needs to match your child's. So first step would be, like Jen said, changing your own, and then assuming you've done that, go to phase 2. All right, Izzy, what else do you have for us?
All right. How will we know that our LGBTQ loved ones are in irretrievable danger in this country? What are tipping point indicators in your opinion? And then I will add, and is there anything we can do?
Yeah, this is a really painful question because I don't know that I can tell you what to watch for on a political scale or on a legislative or legal scale. What I would suggest is that if you have a loved one that you're worried about, you maintain open communication with them and come up with ways that you can check in on them and make sure that they're personally doing okay. And then also that they have a way to signal to you that they're not, right? And that could look like any number of things, right? It could be, listen, we're going to talk every Tuesday morning at 10 a.m. And if I don't hear from you, I'm going to assume something has gone wrong and I'm going to send help, right? It could be agreeing on a certain code word or code phrase that either signals I am doing okay or signals I'm not. Something that they can communicate to you in a way that they're not worried someone will hear it and see it as a signal, right? So the best thing you can do is stay in touch with the people you care about and have some procedures or protocols for how you're going to stay in touch and how they can tell you or signal to you if they need some help. And then if you can come up with, I mean, I hate that this is what we're talking about at this age of our country, but having a plan for if there is a tipping point, if things get bad enough that they don't feel safe or don't feel they can stay here, where will they go? How will they get there? Who's going to help them? And have that plan so that they can deal with it if they do reach that tipping point.
Great, thank you. Um, Does it potentially put you in danger these days to change your birth certificate or passport gender marker?
From a legal perspective, it shouldn't, right? These legal tools exist for a reason. And, you're not in trouble legally for taking advantage of something you're allowed to do, um, socially and sort of publicly, possibly, right? The nice thing is that most of the tools we've talked about today are things that are actually done outside of the courts. Some of them, like some of the adoption procedures, they're at least a public record, but it's not like there's a public announcement that you're doing it. So they tend to be a little more subtle. Most of, in particular, what Jen was talking about with regards to the confirmation adoptions, one of the nice things is you're not having to do some of the publication things that you might otherwise do. One area is for some name changes, you do have to publish that you are changing your name. And so that is something that will draw attention. It's something people might notice. And so you may want to think strategically about where you're going to do that publication notice and, what options you have to minimize that risk. I don't know that most people even realize where those public notices go, but I would imagine that the type of people who would care enough to hurt someone for doing that might know where to look for that. So sadly, I can't promise there's no risk.
And one thing, when it does come to adoptions, and those are hearings held at a courthouse, but they are sealed, and
Right.
typically the names are not reflected on any announcement. So there is some protections. Obviously, judges, the court clerk will know, and you're there in a courtroom, but they do keep everyone else out. So the public is not able to enter that, and they do protect your names.
All right, well, that's our last question for this evening. Any final words before we all sign off tonight?
I think I end every one of these webinars with a suggestion that if you have questions that you're not comfortable sharing in a group or that you're still formulating in your head, it is always a good idea to reach out to an attorney somewhere and get some advice about this. When you're choosing an attorney in this arena, look for attorneys who seem to have experience in this area, right? Who talk about it on their websites, who you get as a good referral from a friend or a friend of a friend that they know what they're talking about. But definitely, if you have questions or concerns, please do talk with someone that might be able to give you better advice about your actual case.
All right. Well, thank you so much. And as Katie alluded to, we are offering free consultations at our offices over the phone via Zoom with one of our attorneys. If you have more questions, just give our offices a call and give them the code Wiser Together or mention the webinar and they'll be able to set you up with one of those free consultations to speak with an attorney and get some more of your questions answered. With that, we will sign off here tonight. We hope you all have an excellent Colorado Wednesday. We hope to see you at another Wiser Together webinar. Have a good evening, everyone.